Um, Tonight we're going to talk about a couple of topics. We're going to talk about the United States court system a little bit. And then we're going to talk about an audit, a civil tax exam, again under U.S. tax law. But the principles of handling an examination, they're going to be the same, pretty much, under any system that you're operating under. I think most of you were here the other night, yes? Do you remember we talked about the Davenport case, that terrible case where a little girl is killed and the court rules that the defendant's rights were violated? Do you recall that case? Yes? Do you know, after my talk, I can't tell you how many of you came up to me very upset with the decision. Very upset. This can't be right. We're going to start there tonight. The reason that the decision in that court was correct, it was a terrible decision, but it was the correct decision, was because of the issue. The issue. The issue was not whether the man killed the little girl. I know that's impossible sometimes to understand. The issue was whether his rights were violated. That was the issue in the case. So why do we start there tonight? Because tonight, when you think about taking a matter to court, you have to think about the issue. What is the question? You have a saying, I think I might have mentioned it last time, if you have a case where the law favors you, you have very good law, then you argue the law. But if you have a case where the law is against you, when you look at the precedents, when you look at your statute, the law is against your client, then you argue the facts. And that's the way a lawyer approaches litigation. The issue. Second thing, global comment I'll make about courts is if you become lawyers, or if you are lawyers, if you're assisting lawyers, you have to know procedure. Procedure. The rules of the court. When I was a law student, the professor told me, you will win more cases on procedure than you ever will with the law. I thought that was a silly statement. But there was some truth to it. Case we had in our office, Tian and Constantino office. When you begin a case, typically, the taxpayer files, and we'll talk about different courts, in the United States Tax Court, a petition. And the petition puts the facts of the case in, usually not in great detail, just enough, and you make it, explain what relief you're looking for. The government has to respond to your petition. They have to file an answer. I drafted the petition in a precise way where there was the burden was on the government to respond in a precise way. I didn't have very good law. I filed my petition in a special way. The attorney for the government in the United States, the lawyers that work for the government, are very, very busy. They have more cases than they can handle. So sometimes they get a little careless. When the lawyer read my petition, he did not appreciate the nuance. He didn't appreciate the way I drafted the petition, and he responded incorrectly. After I got his response, I made an immediate motion to dismiss his case. The government failed to respond to my petition properly. The case was dismissed. Was that the right result? For my client, yes. Lawyers in the United States, our responsibility, our ethical responsibility, is to represent our clients as zealously as possible. That's our job. All I care about is my client. My job is to protect my client. Now, with that, there are rules. You cannot lie. You cannot misrepresent. Your papers that you submit to the court have to be factually accurate. You can never put a witness on the witness stand that you know or you believe is going to lie. So if a witness, and we've had clients who have, well, I'll give you a case. You tell me. The case involved a client who owned horses. Not the kind you eat, the kind you ride, okay? Horses. He was treating his horses, the horses he owned, as a business. It's very important in the United States because if you treat this activity as a business, then you get to take the deductions, the losses for the expenses for the horse. Now in the United States, a lot of people own horses for their own pleasure, a hobby. My wife owns 3 horses. It's true. She has 1 husband, 3 horses. That is her hobby. So the money that we spend on her horses is not deductible. It's not a business. But a lot of people in the United, particularly where we live, in our community, there are a lot of horses. There's farms and ranches, and people ride horses and have those activities. They want to treat it as a business, but it's not really a business. It's a hobby. My client had 1 horse. His daughter rode the horse, spent a lot of money on the horse, and he treated it as a business. And the IRS audited him. They examined him. They said, you know what? You're not entitled to those expenses. You're not entitled. That's a hobby. That's for your pleasure. It's not a business. This man insisted it was a business. Yes? Sorry? Oh. This man insisted it was a business. As proof, he said to me, so we had our data and our information. I filed a petition in tax court. We're getting ready for trial. We're gathering evidence. Basically, it was going to be his testimony. He was going to get on the witness stand and he was going to tell the court, this is what I did, this is the way I ran it, these are the records I kept, separate bank account, I went to all these shows, I made this investment, it was a business, it wasn't a hobby, it wasn't for our recreation. Yes, my daughter was the only one who rode the horse, but she's an expert. He was going to testify to that. He was believable. He was believable. When you listen to him speak, you would think this makes sense. So I had enough confidence in my client that he could tell a story that you'd believe, and my ability to get it out of him as his lawyer, that we would take this opportunity to try the case. He told me one other factor. He said, not only did I work on this, but I hired, truly, the man's name was Paul Vallier. Paul Vallier is one of the most important horse brokers in the United States. Very, very wealthy, very successful, well known in the industry. He said, Paul Vallier and I worked together. Really? Yes. I said, we could put Paul Vallier on the witness stand to say this man really was in business. The only problem was, it was 2 weeks before trial, before my client decided to tell me this. Secondly, I tried to call Paul Vallier. Now, we're in New York State. Paul Vallier was in Rhode Island, which is another state not too far from New York. I called Paul Vallier. I had a private investigator sent Benvey, to go speak to Paul Valier. We tried to find him so that I could get him to come and testify. Now, in the United States, if you ask someone to come to court to testify, they don't have to come. They could say no. Then you could issue what's called a subpoena, and you could command him to come to court. But if you want a witness to testify for you, subpoenaing him may not be the best strategy. Does that make sense? Because maybe he's not too happy that you're forcing him to come to court. In any event, I could not find Paul Valier. The IRS, in my negotiations, because you're always trying to settle the case before trial. You want to try to resolve the case. I say to the IRS lawyer, you know, my client worked with Paul Valier. My client, she said, Paul Valier? She knew him instantly. I said, yeah. She said, really? I said, yeah, and when he gets on the witness stand, he's going to tell the judge, oh, by the way, I've consulted with Paul Valier, I bought horses with Paul Valier, I used him as a broker, we bought horses together, we sold horses. Okay, it's the eve of trial. The IRS found Paul Valier. I couldn't, the government did. 2 days before the trial, the IRS lawyer calls me up. She says, Jim, good news. I served Paul Valier with a subpoena. He's coming to court to testify for the government. I said, excuse me? She says, yes. And you know what he's going to testify? He's going to testify he doesn't know your client, never heard of your client, doesn't like your client even if he knew him. He said, and anything that he can do to hurt your client, he's going to do. That's what Paul Valier told the government attorney. I was getting back to you as a lawyer, your ethical responsibility. You're me. Can I put my client on the witness stand? What do you think? Would you do it?
No.
Why?
Because he lied.
Well, it's his word against his word against the other word. Yes, no?
The one is famous, the other one is nobody.
Say again, please.
One is quite famous, the other one is
Ah,
nobody.
you're going to credibility. Exactly. There was no way this lawyer was going to put that guy on the witness stand. I couldn't do it because I absolutely believed he was going to lie. And my ethical responsibility is never to put a witness on the witness stand that's going to lie. You know, lying is a funny thing. Sometimes people actually believe their story. You'll see that with clients. They'll come in and tell you something, and they'll really believe it. They'll say, this is... Because you can convince yourself of anything if you want. The end of that story is we did not try the case. We managed to settle it and get some relief and move on. And that brings us a little bit into courts and into trials. So I gave you some reading, a little bit. Court system in the United States, there's lots of different courts where you can take a case. And one of the things I asked you to think about was, what do you think is important in deciding whether to take a case to trial? Now again, I'm asking you to think about it from the context of the United States, so that might be a little different in Kazakhstan, but I think the issues are probably similar. So a couple of things you need to know. There are two main issues that distinguish which court you may want to go to. You get a choice. In our country, to take a federal tax case, you have a choice. The two main points that distinguish it is, one, there are actually two courts, but the United States Tax Court is the most prominent, that you can take your case and you don't have to pay the tax first. The government has asserted a deficiency. They say you owe us money. You say, I want to go to court, but you don't have to pay first. So, but there are other courts where you do pay, and then you file a claim for a refund. So, first issue, do you want your client to pay or not pay the tax? You have a choice. Second, which is an interesting issue for me, is some courts, you do not get a jury. You know what a jury is? Okay. Some courts, you can ask for a jury, and you can get a jury, some not. Let me ask you a question. Thinking about a tax case, how do you feel about having a jury? If you don't have a jury, then the judge makes the decision. The government puts in its case, you put in your case for your client. None of us are government lawyers, by the way. We all represent taxpayers here. That's the right side of the table. Okay, so how do you feel about a jury? Would you prefer a jury? I mean, obviously, the facts of the case have something to do with it, but how do you feel about trying your case in front of a judge, where the one man or woman makes the decision, or in front of a jury, there's 6 people in a civil jury. How do you feel? Any thoughts?
Jury.
Who would say jury? Somebody? Tell me why. Why do you like a jury?
There's 6 people and they can argue about the case and maybe they come up to a fair decision. rather
So
than-
you trust the 6 people?
But they do not know what they
Because there were 6 points of
probably
view.
they don't know much about taxes.
Okay, let me.
But they rely on emotions mostly, so it's.
That's interesting.
So you can
Yes.
take the emotions of people, you can play on their emotions.
Yes,
So I think if you are guilty, then use this stuff. These people.
say again.
If you are guilty, you can call jury. If you are not guilty, of course it's judge.
Oh, okay, that's good. I may make a comment. Guilty is in a criminal case. We're not there yet, but here it's either you owe the money or you don't owe the money. Here we're only arguing about money. So you say you don't know the law. That's very important, except, so that might have to do with how complex the case is. The judge, in a U.S. trial, the jury will get very precise instructions on the law. They're called jury instructions. You can't expect people to know the law. So they will get education, and if they don't understand, there'll be a big effort to make sure they understand the law. Well, here's the thing. In the United States, I should tell you this. This is very important. Our judges in the U.S., the vast majority of them, not all of them, but vast majority, are very honest people. They want to get the right answer. That's not the judicial system in every country in the world. Some countries, the judges sometimes are prejudices, sometimes they, in our country, if a judge is found to be corrupt, it's a very bad experience. The judge will go to jail, he'll have fines, he'll be disgraced. They take the physicians very, very seriously. So certainly where you're bringing the case is important. Secondly, let me ask you something. You said jury, whoever said jury. What if your client was rich? Rich client.
You can buy that.
No, we don't buy them. Not a good answer. That may be a practical answer, it's not a lawyer's answer. If your client is rich, is that influence? What do you think? Is a jury better with a rich client, or?
Negative.
I think well, it depends. You
Depends
can
on
choose the jury. And
Jury.
when
Well,
choosing-
let's
when
talk about,
choosing, You can sort of.
well, choosing a jury.
Select
I'm
those who
sorry.
don't be credited.
Let's talk, you said something very important. Both sides pick the jury. The government and the taxpayer, we get to interview people together who want to go on the jury. And we get what's called preemptive right. We get to exclude certain people. So if you were going to be on my jury, and I say to you, so can you tell me a little bit about your background? Well, I was a tax agent for 25 years, and my job was to collect money, seize property, and put people in the street. I'm not interested in you on my jury. Okay? All right. So you get to pick the jury, both sides. You're trying to, and sometimes, depending on your case, you may want the most like for our cases, we want the most educated people possible. The government typically prefers people who have less education, because their tendency will be to believe, well, if the government says he owes the money, he owes the money. Or, I mean, so you're looking for this. Do you know in the United States we have consultants? They make a lot of money to help pick juries, to psychologically profile you and how you might vote, how you might see a defendant, your race, where you're from, your education, your economic position, your job, your family status, married, divorced, all those kinds of questions, which help these consultants pick juries. So it's not so random. Yes, sir.
Which courts don't have like a jury?
United States Tax Court does not have a jury. So even though, now that's a court you do not have to pay the tax first. You can contest the assessment and you don't have to lay out the money. You can do it and not have to pay. No jury though. So the benefit of not having to pay, now you can go to United States District Court. There you pay, and then you file a claim for refund. And when the IRS will deny the refund, there you can get a jury. My experience, and lawyers that we know try these kinds of cases, a lot of these types of cases, you don't want a jury, because most people will go to tax court, and that's going to bring me to point maybe number 2. It's very, very expensive in the United States to try a case. How expensive?
It's easily to pay, and it's enough, yes.
Say again?
It's easily to pay like some fees rather than have some trial with some.
Well, that's actually the question. If you came to our office, we're not in New York City. We're just north of New York. What about 100 kilometers north of New York?
120, 140.
Something like that. So we're more in the country. But if you came to our office and you wanted to take a case to the United States Tax Court, even the most simple one witness, one-day trial preparation, without any problem, you're going to spend $75,000, maybe $100,000 US. So the first question you have to ask yourself, and there's no guarantee of result. There's always a risk, no matter. So what is the lawyer's responsibility? Do you have a case? Do you have a case? Is there something here to litigate? Because it's very expensive. So you're sitting with your client. The client comes in and says, I have this issue. And the government is looking, they've given me an assessment, and I owe them a lot of money. Let's pick a number. 500,000 US. That's a good number. So we're past, the fees. You're at risk a lot of money. What else are you concerned about? What else are you, as an advisor? Because in our office, I think I mentioned last time, we have 4 accountants who assist us, provide forensic support in our process. What other questions, what other concerns? You're the lawyer, you're trying to counsel someone. Should you take the case to court, should you not? What are you interested in discussing with this client? What do you think is important, other than the expense of it? Anything else come to mind? How about the time? The United States Tax Court is going to take you maybe 3 years. Maybe. Everything goes. You go to federal district court where you can get the jury, 6 years, maybe 7 years. We have a case right now that started in, although it ended up going criminal, but it started in 2006. It's 2014, and we're still about 2 years away. So time, maybe time's important.
Interest, Jimmy?
In the United States tax court, where you do not have to pay the assessment, you can fight it in court, you can get a trial, have a judge hear your case, but the interest keeps running on the assessment. So when the government determines you owe them money, it's like a loan. So every year, every day that goes by that you don't pay it, it gets bigger, bigger, bigger. And right now, the way the interest rates run in our country, the law, the government, the rate they charge you is based on what we call the prime rate. You guys know what that, the bank rate. They look at the bank rates, the published bank rate that the banks would charge, and then it's a factor of that. All right. I can see you're not going to cooperate, so we'll try another point. Complexity. You think that's important? And if you have a really complex case, complicated, a lot of facts, complicated law, a new issue, something novel, something you haven't seen, does that influence you? We have litigated under very unusual circumstances. They're always special circumstances. A case where we were trying to change the law. We thought that the decisions in this particular area were incorrect. We thought that there was some court decisions, some precedents we call that, prior decisions on a matter, and we thought they were not correct. And we wanted to challenge it. Now, we didn't win that case. I know, you can't imagine me losing a case, but actually, we've lost a few. But it influences you. You start thinking about these issues because complexity also tells you where you're going to take the case. Because not all judges are equally as smart and or equally sophisticated. Two other little points I'll mention. One other thing about the United States. The law is not the same in every jurisdiction. The law is not the same in every jurisdiction. I repeated myself. Why? We have 13, the United States, right? We have, it's split up geographically into 13 circuits, we call them, circuits, 13 courts of appeal. You could be in California, and the law could be on a particular issue, could say one thing, and you could be in New York, and the law could be just the opposite. A conflict in the circuits. You can have that in our country. So, New Orleans. Any of you heard of that city, New Orleans? Yes, of course. No? Okay. So New Orleans is in the 5th Circuit. We're in the 2nd Circuit. Yeah. Right. Just testing. Okay. So we're in the 2nd Circuit. If the law in the 5th Circuit is good for me, I still have to take my case where the taxpayer is located. We're in the 2nd Circuit. The law of the 5th Circuit is not NOT, binding on the 2nd Circuit. So the judges in the 2nd Circuit could decide completely the opposite. Now, they use the term, it's persuasive, it's helpful, but they don't have to follow it. So one of the questions you have to ask yourself, because you don't get to pick the jurisdiction where you're